Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court today because you have a case in County Court at Law Number 2. The case that you have is classified as a misdemeanor case. Your case is a criminal case. Criminal cases are divided into felonies or misdemeanors. If you had a felony offense, your felony offenses are normally referred to as your most serious type of criminal offenses, whereas your misdemeanor offenses are normally referred to as petty offenses. It does not mean that they're not serious. It just means that they are not as serious as a felony offense. And what I mean by serious, I'm talking about the punishment range. That is the possible punishment that you could get if you are convicted of a felony or misdemeanor. Felonies are divided into 5 categories. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and state jail felony. If you are convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail and a fine up to $10,000. If you're convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary and a fine up to $10,000. If you're convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years and a fine up to $10,000. If you're convicted of a first-degree felony, the range of punishment is minimum 5 years to maximum to 99 years to life and a fine up to $10,000. Now, if you're convicted of a capital murder, the range of punishment is life in the state penitentiary or death by lethal injection. The case that you have here, as I mentioned earlier, is a misdemeanor case. Misdemeanors are divided into 3 categories. You have a Class A misdemeanor, Class B misdemeanor, and a Class C misdemeanor. Your Class C misdemeanors are normally cases that are handled in the JP court, which is the justice court, or cases that's handled in the municipal court, the city court. For example, a speeding ticket is a Class C misdemeanor. Not wearing your seatbelt is a Class C misdemeanor. Now, if you are convicted of a Class C misdemeanor in the city court or the JP court, the way it gets to this court is by you appealing your conviction, and then it comes up to this court. When it comes up to this court, the range of punishment does not change. The range of punishment is still the same. So if you're convicted of a Class C misdemeanor, the range of punishment is by fine only. That means we can't give you any jail time. We only can give you a fine. However, if you do not pay your fine, then a capious pro fine can be issued. That is, a warrant for your arrest can be issued to set out the fine in jail. If you are convicted of a Class B misdemeanor, the range of punishment is 0 days to a maximum of 180 days in the county jail, a fine from $0 to $2,000, or you could be given both such fine and confinement. If you're convicted of a Class A misdemeanor, the range of punishment, minimum 0 days to a maximum of 365 days, which is a year in the county jail, a fine from $0 to $4,000, or you could be given both such fine and confinement. Now, you may be eligible for probation. There are 2 types of probation. One type of probation is called regular probation. With the regular probation, it does result in a conviction on your record. However, there's something that is called judicial clemency, which means the court can set the conviction aside. And if the court sets the conviction aside, the way that happens is you have to finish your probation. There cannot be any more time left, and you have to be discharged off of the probation. If those 3 things happen, the court can grant you judicial clemency. And if the court grants you judicial clemency, then your case is disposed of or taken care of, or you would not have a conviction on your record. However, if you get a subsequent conviction later on, then this case can be brought back up. It can be revived, resurrected, or brought back up, and it can be used against you. And if you try to get a license with CPS, they could deny giving you a license, or if you have a license, they can revoke or suspend the license that you have. Now, the other type of probation is called deferred adjudicated probation. It does not result in a conviction on your record. And if you successfully complete the probation, the case will be dismissed and you may qualify for what is called a non-disclosure. A non-disclosure means that we cannot disclose to the public the fact that you are on deferred probation. However, certain agencies, certain state agencies can have access to that information. And in some cases, you may be eligible for a non-disclosure for a regular probation. And you would have to talk to an attorney about that so they can advise you as to whether or not you may or may not be qualified for non-disclosure if you get a regular probation. Now, as a defendant in a criminal case, you have rights. One of the rights that you have a right to have an attorney. That document or those documents that has been handed to you on the clipboard talks about your right to have an attorney. The first document is titled Judge's Explanation of Rights to Defendants Without an Attorney. And on that document, it states that you have three options. That is, you have three options regarding your right to have an attorney. Number one, you have a right to hire an attorney. Number two, if you cannot afford to hire an attorney, you may request that an attorney be appointed to represent you. Or number three, you may waive or give up your right to have an attorney and represent yourself. Now, if you want an attorney to represent you and you have enough money to hire an attorney, then your case will be reset. Reset means you'll be given another court date from the date to give you time to hire your attorney. If you want an attorney and you do not have enough money to hire an attorney, you would need to fill out a financial questionnaire. The questionnaire is titled Jefferson County Affidavit of Indigence, and should be on your clipboard. And you will fill that affidavit of indigence so that the proper person may determine whether or not you qualify for a court-appointed attorney. If you want to waive your right to have an attorney, waiving means giving up your right. If you want to give up your right to have an attorney and you desire to represent yourself, before you can talk to the prosecutor. The prosecutor, we have two prosecutors. Prosecutors, they work for the state of Texas. They work for the Jefferson County District Attorney's Office. Before you can talk to them about settling your case, if you are representing yourself, you must first sign a waiver of counsel. And that waiver of counsel is also attached to the clipboard. Now, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, child custody, immigration status for non-citizens, and employment. Now, if you choose to represent yourself, that is, if you choose to proceed without an attorney and represent yourself, you may change your mind at any time, and you may request that counsel be appointed for you. At the bottom of that document is titled, in bold letters, Defendant's Choice. Mark initials next to only one choice. If your choice is, I want to reset my case to hire my own attorney, then you'll place your initials on the first line to the left. If you have already hired an attorney to represent you, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If you want to apply for a court-appointed attorney, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney in your case, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If you want to waive your right to an attorney, that is, give up your right to an attorney and represent yourself, then you will place your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign your name on the line that is titled defendant, and you will date it today's date, April 11th of 2023. Now, for those of you who will be waiving your right to an attorney, that is, giving up your right to attorney and representing yourself, then you would have to read and sign the next document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding in the Trial. And it reads as follows. I have been advised of the nature of the charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 11th day of April of 2023 by the County Court at Law Number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel, and if that is your choice, then you will sign your name on the line that is titled defendant, and then you will date it today's date, April 11th of 2023. As a defendant in a criminal case, you also have a right to have a trial by jury. Where those young people are sitting in that area over there, we call that the jury box. Now, 6 citizens from Jefferson County will be selected to serve as jurors in your case. They will listen to all of the evidence. After listening to all of the evidence, they will deliberate, and then they will decide whether or not you are guilty or not guilty of the charges. Now, you can, or you have the right to waive your right to have a jury trial. That is, you will not be having 6 citizens from Jefferson County deciding whether or not you're guilty or not guilty. If that's the case, then your case will come before the judge, before me, in one of 3 ways. It can come before the court by way of a trial. We call that trial a bench trial. That means that it's a trial by judge only. Now, you can waive the right to have a trial by judge only as well. Now, if you do so, then you're indicating to the court that you will be entering a plea in this case. Now, a person can enter a plea of either not guilty, a person enter a plea of not guilty is saying they didn't commit the offense that they've been charged with. If they enter a plea of guilty, then they're telling the court that they committed the offense that they've been charged with. Or if they enter a plea of no contest, then they're telling the court that they will not be fighting or they will not be contesting the charges. Now, if you enter a plea of guilty or no contest, your case will come before the judge. Now, it will come before the judge, as I mentioned earlier, either by way of a bench trial, if you enter a plea of no, not guilty. Now, if you enter a plea of guilty and no contest, it will come before the judge by way of a plea bargain. Now, there are 2 types of plea bargain. One type of plea bargain is an agreed plea bargain, and the other type of plea bargain is an unagreed plea bargain. What a plea bargain is, it's an agreement that you have worked, you talked to the prosecutors, and you worked out an agreement to settle your case. If you work out an agreement to settle your case, we call that agreement a plea bargain agreement. That plea bargain agreement will come before the court, and then the court will decide whether or not it will go along with that plea bargain agreement or not. If the court does not go along with the plea bargain agreement, you'll have a right to withdraw or take back your plea. So for example, let's say you and the state has worked out a plea bargain agreement and they have agreed to give you 1 day in jail. And it comes before the court and the court say, well, I'm going to reject that plea bargain agreement. Then you could tell the court, well, I take back my plea of guilty and no contest. In essence, I don't want to go forward because you're rejecting my agreement. You have a right to do that. Now, if the court does accept the plea bargain agreement, and if you decide you would like to appeal the case, that is, you believe that you've been wrongfully convicted, or the court, violated your rights in some way, then you would like to appeal, or you've been wrongfully convicted, then the court has to give you permission to appeal your case. And what an appeal is, it will go up to a higher court. The higher court is the Ninth Court of Appeals. They're located right above us on the 3rd floor. They will look at your case and they will decide whether or not to grant or deny your appeal. If they grant you appeal, they can just simply find you not guilty, or they can send the case back down to this court, order this court to, they can order this court to give you a whole new trial. Now, if they deny your appeal, then you can appeal it to a higher court than them. You can appeal it to the highest criminal court in the state of Texas, which is the Texas Court of Criminal Appeals, which is located in Austin, Texas. Now, you would have to file what is called a petition for discretionary review. What that basically means, you'll be asking the Texas Court of Appeals, Texas Court of Criminal Appeals to review your case to see whether or not your appeal should have been granted, whether or not you've been wrongfully convicted, or whether or not this court committed an error by convicting you. Now, if they can do one or two things as well, they can grant the petition for discretionary review, or they could deny it. Now, when you file a petition, the pro se petition for discretionary review, that means that you'll be filing it on your own. You will not be represented by an attorney. You'll be pro se. Pro se means I'm representing myself. Now, if they grant your pro se petition, they could either find that you were not guilty and your case is over, or they can send the case back down to this court and order this court to give you a whole new trial. Or if they deny your pro se petition, then your conviction at that point will stand. Now, as I mentioned earlier, if you have a right to have a trial by jury, you could waive it. If you waive your right to have a trial by jury, you can have a bench trial. That's a trial by judge only. Or you could have a plea bargain agreement. It could be an agreed plea bargain with the state. The court does not have to follow. Or you could have an unagreed plea bargain. Unagreed plea bargain means that you and the state have not been able to reach an agreement, and so you want the judge to decide what your punishment will be in your case. We call that an unagreed plea bargain agreement. Now, you also have a right to have witnesses to come to court. Witnesses sit in that chair over there. We call that the witness stand. And a witness, what they do is testify. They can testify for you, against you. If you're representing yourself, or if you have a lawyer, you can ask questions, or your lawyer can ask questions. We call that either direct examination or cross-examination. Now, you also have a right to waive or give up your right to call witnesses. Now, if you waive your right to call witnesses, that does not mean that the state will not be calling witnesses, because they will be calling witnesses in the case that they have against you. You also have a right, a Fifth Amendment right against self-incrimination. You may have heard referred to as taking the fifth. And that simply means you have a right not to testify against yourself in your case. Now, you can waive your Fifth Amendment right. Now, if you waive your Fifth Amendment right against self-incrimination, then you will be testifying against yourself, or you'll be testifying in your case. Now, the other thing is you have a right to have discovery. Discovery means you have a right to see the evidence or discover what the evidence is. The evidence is what the state has against you. For example, they may have witness statements or videos, audio recordings. They may have photos. They may have documents. They may have some type of instruments. All the things that they have that they consider as evidence, you will have a right to have access to that. In essence, you can review it and to prepare for trial. Now, if you're represented by an attorney, your attorney will have access to that information, and he can discuss that information with you. Now, as a defendant in a criminal case, those are the rights, basic rights that you have for arraignment purposes. Now, the other thing is everyone that's here today, you've been arrested, you're out on bond, you're either out on a cash bond, which means you paid the full amount of the cash to get out, or you're out on a surety bond, which means that you have a bondsman. You paid the bondsman a percentage of the cash of the total bond to get out. Or you're out on a PR bond, which means you're released without paying any money. You're released under your own personal recognizance. So you had a promise to come to court today. Now, every day that you spent in jail, that jail time could be used as credit towards your punishment. So for example, let's say you in the state have worked out a plea bargaining agreement for 5 days in jail. Now, if you've already served 5 days in jail, that means you won't have to serve any more time in jail on this case, because you've already served 5 days in jail. Therefore, you'll be given credit for the time that you've already served. Now, if the state is offering 7 days, you serve 5 days, that means you will have to only serve 2 more days. Now, every day that you spent in jail also goes as credit of $100 towards your fine and court costs. So for example, if the state is offering you a fine and court cost of $500 and you spent 5 days in jail, that means 5 days in jail is $500. You won't have to pay a fine and court cost because the time that you spent in jail has already paid it off. Therefore, the fine and court costs will be taxed and retired. You won't have to pay it. Now, if they're offering fine and court costs of $700 and you spent 5 days in jail, that's only $500. So therefore, you would have to pay $200. Now, if you can't pay it on the day that you do the plea, then we could put you on a payment plan. And you could pay it in monthly installments until it's paid off. Now, if you cannot pay it in monthly installments because you do not have any income, that's not a problem either, because we can convert your fine and court costs to community service. Now, every hour of community service that you do at a nonprofit organization, you will receive $12.50 that will go toward your fine and court costs. Now, if, for example, if you work 8 hours one day, that's $100 that will go toward your fine and court costs. Now, the other thing is if you, Jefferson County has a program that is called pretrial diversion. It's for first-time offenders. If you haven't been in trouble before, then with pretrial diversion, they would dismiss your case and you can get an expunged from your record. Expunged means erased, deleted, or wiped off your record. And the way it works, the way you qualify, it has to, as I mentioned earlier, you cannot have a criminal history, first-time offender, first time getting in trouble. Then you have to have an attorney to assist you to get in the program, and it cannot be an offense involving unlawful carrying a weapon or resisting arrest. But all the other charges, it does qualify for pretrial diversion. Now, if you are a veteran of any one of the branches of the United States military, Jefferson County District Attorney's Office also has a program that is called Veterans Court. The Veterans Court is for veterans only. It's part of the pretrial diversion program. You get into the program, you complete the program, they dismiss the case, you can get it expunged from your record. Only thing you have to do is be a veteran of any one of the branches of the United States military. Now, Jefferson County, as I mentioned earlier, has those two programs. Now, this court has a program that is called the Community Safety Initiative, the CSI program. With the CSI program, we have partnerships with local agencies in our community, and the program is designed to address the issue of what we call recidivism. Recidivism means that when people commit crimes over and over, the way we address it is by having this program. And the program is designed to make Jefferson County a safer place for all of us to live, work, go to school, raise our children, and go to church. And the way the program works is through the partnerships that we have with the agencies. One of the partnerships that we have is with Spindletop. Young people that I introduced to you earlier, they're from Spindletop, and they will come to you in a few minutes to talk to you about their Spindletop program. But basically, what Spindletop would do, Spindletop is our local mental health agency. And you don't have to be insane, you don't have to be incompetent to participate in the program. You could suffer from depression, anxiety, bipolar schizophrenia. It could be PTSD, a whole host of other mental illnesses, and they'll be able to address it. And the way they address it is by having, one, a private interview, and then two, they would do an assessment. And then after the assessment, they will develop a treatment plan, either outpatient or inpatient, depending on your mental health needs. They also have a program that is called ATAR, it stands for Addiction Treatment and Recovery. And that program, along with OZAR, and OZAR is by our local Drug and Alcohol Council, and OZAR stands for Outreach, Screening, Assessment, and Referral. Those programs are drug treatment and alcohol treatment programs. What they would do a screening. You first get a screening, then they would do an assessment, and then they develop a treatment plan, either outpatient or inpatient, depending on your needs. If you are unemployed, do not have a job, or if you're looking for a better job, then we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you are trained in one of those areas that you select, then they will assist you at getting a job in the area that you're trained in. Now, if you have not graduated from high school, they also have a program for a GED program. Now, all the programs that I just mentioned are free. It does not cost you anything. The only thing you have to do is have a desire to be in the program. It does not cost the county a cent either. And I tell people this all the time: when you come to county court at law number 2, we do not have court as usual. We have unusual court. It's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that comes before this court. And we're also trying to make a difference in Jefferson County by making Jefferson County a safer place for all of us to live, work, go to school, raise our children, and go to church. Now, the other thing is, with this program, we do not just arrest the problem, we address the problem. That is, we do not just give time, we take our time. And we believe that by taking our time, we could produce productive people. And if we produce productive people, we believe that productive people will not commit crimes. Why? Because they have too much to lose. So if you're interested in that program or any one of these programs, just let us know, and we'll be happy to get you the information that you need so that you can get in any one of these programs. Now, the other thing, out of all of these programs that I just mentioned, can be used as community service. For example, let's say you was ordered to pay a fine, you couldn't pay the fine, we converted it to community service, and you're in one of the programs. Let's say, for example, while you're in the job training program, every hour that you're sitting in class, 1 hour, you'll be 1 hour in class, 1 hour will go to for community service, and the other hour you'll be given $12.50 that will go toward your fine and court costs. So, and that's the same thing. The same thing is true for being in the drug or alcohol program, or being in the mental health program, or being in the GED program. All of those programs can qualify as community service, and you can get credit for while you're in that program, you're doing one thing, but you're getting credit for three things. You're in the program, you're getting credit for community service, and you're paying $12.50 that will go towards your fine and court costs. So yes, you're killing three birds with one stone. You're doing one thing, but you're getting credit for three. So if you're interested, just let us know, and we'll be happy to point you in the right direction so that you can get into the right program. Now, as I mentioned earlier, we have some individuals from Spindletop. We have Deputy Hinton and we have Danny. They're going to come to you and talk to you about the program that Spindletop has to offer. At this time, Deputy Hinton and Danny.
Thank you, Ron.
You're welcome.
Good morning. My name is Steve Hinton. I'm a mental health deputy licensed by the state, commissioned by the sheriff's office. This young lady here is Danny. She is a qualified mental health professional with Spindletop. The reason we are both here this morning is because the judge cares about every single person that comes before the bench. The judge has found, and what statistics prove, that those who have legal issues commonly have mental health, substance use disorders, or sometimes just a lack of community resources that help you with your particular situation. Now, we have no idea where you are in your walk in life. We're going to need something from you. The document you're handing out is HIPAA regulated, is private. But we're going to need to share that need with us in that document so we can best serve you. That document is separate from the court documents, and Danny's going to explain exactly what she will do with that.
Okay, so just like you mentioned, the document is HIPAA regulated. That means only you and I will see it. No one outside here will see it. So the document is basic demographic. There's available information about what your needs are, what resources you might be interested in, what we can help you with. So if you guys just fill that out, right here it shows contact choice. It's either call or text. We call and text one time, you tell us to leave you alone, fine, we'll leave you alone. We won't keep bothering you. Down here, if you're interested in speaking privately today about resources and getting those resources started today, you can check at the bottom, yes or no, for that as well. Spindletop helps with a ton of resources, mental health, substance use, education resources, employment resources, financial resources. So it's not just mental health that we're here to help you guys with. And if you guys need any mental health resources, we are here to provide those as well.
Before you leave here today, I have this flyer. It tells you a little bit about our program and some of the advantages of it, but also on the front, it has a 1-800 number. Should you ever find yourself in an unsafe place, you can call that number and get help immediately. And you don't have to wait for us to call you or text you or whatever you prefer. There's a phone number on here which you can actually go ahead and initiate that call and address it as well earlier. Thank you very much. Thank you, Your Honor.
Okay, thank you, Deputy Hinton. Now, ladies and gentlemen, the paperwork that you have, if you need any help to fill out the paperwork, we have people in the courtroom on our court staff will be happy to help you with the paperwork. Just simply raise your hand and someone will come by to help you with fill out the paperwork. Now, once you finish filling out the paperwork, we're going to take the paperwork up, and then once we take the paperwork up, we have to put you in various categories, and then we're going to call you up one at a time. And depending on whether or not you want to hire an attorney or whether or not you want to see if you qualify for court-appointed attorney or whether or not you want to represent yourself, we'll put you in one of those three categories. Now, this is going to take some time. Now, if you need to use the restroom, there are two restrooms that's right outside the door in the hall. The male restroom is on this side of the hall next to County Court at Law number 3. And the female restroom is on the other side of the hall next to the 172nd District Court. So at this time, the court is going to be in recess to give you an opportunity to fill the paperwork out and to give us an opportunity to go over the paperwork, and then we'll call you up one at a time. But make sure you do not leave the courthouse. Because if you leave the courthouse, what will happen is when your name is called, you're not here, your bond will be forfeited and a warrant will be issued for your arrest. At this time, we'll be in recess